All right, so Chapter 14, Part 2, um, constitutional discovery. By this, we are talking about the obligation of the state to provide um, what is typically called Brady disclosure or Brady material. Um, and that name it represents exculpatory evidence, evidence that indicates that someone besides the defendant um, could have committed the crime. Uh, and we'll talk about in more detail what that might mean. But it was the case of Brady versus Maryland in 1963 that recognized that it violates due process for the state not to turn over evidence that is potentially exculpatory. And without that sort of disclosure, the state is likely to cause false convictions, and the system realized that that is in nobody's best interest, and it makes the court system an unwitting accomplice to false convictions, not to require that exculpatory evidence be turned over. So that's a very common motion that is filed for Brady material, and the case that is in your book, Bagley, is a development of the Brady rule that. And what happened in the Bagley case was the recognition that impeachment evidence, evidence about witnesses that might assist the defendant in calling into question their reliability or truthfulness, that has to be disclosed, that counts as exculpatory evidence. There's a motion for discovery that is on page 274 of your book, and it begins with any and all exculpatory information or materials. So often a Brady request is put into a general discovery motion, but it ought to be requested certainly to preserve the issue of non-disclosure. There's sort of a debate about whether Brady is self-activating, or in other words, whether the DA has to take the initiative, but you don't want to wait on that. You want to make the request for all exculpatory information. All right. So one of the things that happens is that the DA, the prosecution, has a right to request certain things that are in discovery from defendants, and what they typically can have are the objects, photographs, documents that a defendant intends to use into evidence, and scientific tests where a party is, where the defendant is going to call that expert as a witness if they have some favorable testimony that's favorable to the defendant. Now, what the state is not entitled to is the investigative work product of the defense investigation unless it is going to be used at trial. So in other words, you don't have to hand over evidence of your client's guilt. There's no requirement to do that if your investigator goes out and discovers yet another witness who is an eyewitness to a murder. You don't have to turn that over. But if he goes out and finds a witness that says that your client was elsewhere, or that they in fact saw another person commit the crime, if you're going to utilize that witness, you have to make disclosure ahead of time, and likewise documents, tangible items that you intend to use. Okay. This Williams v. Florida case talks about the constitutionality of requiring the defendant to provide advance notice of an alibi and the alibi witnesses. Sorry about that. The concern was that if you provide advance notice of alibi witnesses, it allows the state to go and dig in to their testimony, proposed testimony, and discredit them, or perhaps find out that they're not as sure of things as they might tell the defense they are, and so forth, and that it somehow assists the government in convicting the defendant. And so the court looked at that and said that's really not so, and that it's not fair to have the government be surprised by the alibi defense or witnesses that may support it, that they have the right to investigate that defense, and that the defendant can't, on the grounds of not incriminating himself or herself, refuse to provide that information. In fact, it ought to be favorable information. So the case doesn't make a ton of sense, except that it would give the state an opportunity to go and chip away at the defense, and somehow that seemed to be unfair to the appellant in this case. But it certainly is the law that discovery is reciprocal. All right, so if the state doesn't comply with discovery in a timely fashion, their evidence can be barred from being used, or if there's considerable misconduct, the state could be limited in, for instance, seeking the death penalty. If there's been a lot of misconduct about discovery, but typically what happens, if there's enough abuse and suppression of evidence, the court has the ability to dismiss the case, and you might look at the limits of that by examining the Daniel Moore case in Morgan County. There's written appellate opinions about that case, and plus one of the TV news magazine situations like 48 Hours or a program like that did a investigation of the Daniel Moore case that ultimately was a conviction and death sentence overturned, but first dismissed, but dismissed by the judge for discovery violations. In fact, the case was then reinstated, but he did get a new trial. The second trial ended in a hung jury, and then there was a third trial in which Daniel Moore was acquitted. So anyway, that would be some interesting viewing. Very fascinating case that happened in Decatur about now 20 plus years ago. All right. So that's the end of the discovery section. The next issue that's brought up is statutes of limitation. Like civil cases where there are statutes of limitation, there are time limitations on prosecution, and they can vary between 3 years, 5 years, or more, up to and including crimes that have no statute of limitations. Um, so, with misdemeanors, it's a year. Um, so you look at the statute of limitations as a possibility, um, but oftentimes the most serious cases, the most difficult to prosecute, are cases with no statute of limitations, and those are typically sex crimes, certainly sex crimes against children. Murder has any statute of limitations. So, but occasionally you will have situations where the statute of limitations is an issue and you should be alert to it. The statute of limitations is met by either an indictment or the issuance of an arrest warrant. So if the statute of limitations is 5 years, then within those 5 years, there has to be either an indictment returned or an arrest warrant issued for the initiation of prosecution. If a person there's some discussion of tolling, TOLLING, tolling the statute of limitations, essentially stopping the clock from running if a person is fleeing from justice and otherwise in hiding to avoid arrest. So that can defeat a statute of limitations motion to dismiss. That is something that if the statute of limitations is not met, that would subject a case to being dismissed. Okay, so the next issue is speedy trial issues, and I would suggest that you understand the difference between speedy trial in the federal system and the state system. In the federal system, there is a Speedy Trial Act, which says that basically at the time of an indictment, the government must be prepared to take a case to trial within the next 90 days. Now, that sounds pretty quick if you operate in the state system, and it is, but there are ways in which you can stop the speedy trial clock from running if there are legitimate problems with witnesses or like for instance, now the COVID-19 shutdown is something that is beyond control of the government and is said to be a continuance based on the interests of justice, because rushing to a trial is just simply not practical under the current circumstances. Excuse me. In the state system, there is no defined time for what is or is not a violation of the defendant's right to a speedy trial. There just isn't a formalized Speedy Trial Act in the state system. Whether or not there has been prejudicial delay depends on a number of factors, but one of which is the delay beyond the control of the state? If it's something that just by its nature is not the fault of anyone, there's going to be less that weighs in favor of the defendant in claiming that he or she didn't get a speedy trial. Then, backlogs that are happening at the forensic science labs are sometimes causing dismissals because there just simply is an intolerable delay, but there's just no bright line. You have to have a judge that believes that if there's going to be delay dealing with forensic evidence or something like that, um, that the person, the arrest, the prosecution should not be initiated, and a person shouldn't be held in jail um, awaiting a trial that just gets delayed over and over again. Um, Another thing is the delay in some way prejudicial? Has it caused an availability of witnesses due to death or some other factor, um, or availability of records? Um, people, institutions purge records, banks, hospitals, so on, will purge records from time to time. And so the lack of a speedy trial could, in certain circumstances, um, cause a person to be unable to produce their defense. Um, but in any event, one of the uh, other factors in deciding whether a speedy trial um, violation has happened is whether or not the defendant has asserted his right to a speedy trial, that is, has actually requested a speedy trial. Now, here's what this lawyer says. Time is generally, so long as you are not um, in jail indefinitely awaiting a trial date, time is generally on the side of the defendant, because the burden's on the state. They have the burden of proof. They tend to have more witnesses, so more witnesses can be lost for one reason or another, um, or move, retire, leave the jurisdiction, etc. Um, in instances where clients are in jail, I still, if the stakes are high, like capital cases, I certainly tell people, look, you do not want a speedy trial, because a lot of things that happen with the prosecution case is just waiting and good luck on the part of the defendant that things happen. Uh, the more time you have to discover things, the more time you have for a lying witness to recant their testimony. So I am not a big fan of speedy trial motions. Um, Usually, I'm up for the wait if the client is, um, and certainly if they're on bond, because um, there's just time is generally the enemy of the state, not the defendant. The next topic is double jeopardy, um, and that is a um, right that grows out of the Fifth Amendment that says that the person shouldn't be held to answer for the same offense twice. What this essentially means is that the government's opportunity to prosecute you is a one and done situation. They can't have a situation where the defendant's found not guilty and they just simply get another shot at convicting you. A not guilty um, will bar a retrial um, for the same offense, even if they discover some compelling evidence later on. Um, but there can be situations where cases are have an ending that is short of a, a verdict that can allow retrials. There can be situations where, like a deadlocked jury, is not a bar to a second trial. Misconduct by the defendant or the defense counsel won't bar a second trial. Now, misconduct by the state will. And then, if a defendant asks for a mistrial, then except circumstances where there is misconduct alleged by the state, it acts as a waiver of a retrial. So you can't ask for a mistrial due to a unavailability of a witness that's beyond your control, and then say, "Oh, but you can't try me again." I would say a good example of that is a case I had where there was snow and icy conditions, and witnesses, primarily the witnesses were in Huntsville because this deceased infant was treated at the Huntsville hospitals. They lived in Lacey Spring, which is closer to Huntsville than the hospitals in any hospitals in Morgan County. And so they just simply crossed the river and went to two different hospitals in Huntsville, and those doctors couldn't get across the bridge to testify. So we had to declare a mistrial, and then there were some experts who, although they were in Miami, one was, and it was perfectly sunny, they couldn't travel to the jurisdiction because, their flights would be routed through Charlotte or Atlanta or other places where the ice and snow conditions were going on. So sometimes you have mistrials that are at the request of the defense or at the request of the prosecution under those kinds of circumstances that don't. But if a defendant requested it as a waiver of a double jeopardy claim, jeopardy does not attach in a case, or the case is not subject to a double jeopardy claim until the original prosecution, the initial prosecution, gets to a particular point. If it's a non-jury trial, jeopardy attaches when the first witness is called. Okay, if it's a jury trial, then jeopardy attaches when the jury is impaneled and sworn. And after that, and only after those specific milestones in a non-jury case or a jury case, do you look at whether or not double jeopardy has been violated. The next issue is whether there can be whether a successive prosecution violates the double jeopardy rule, or whether a charge presents a different, perhaps growing out of the same circumstances, presents a different charge that's not subject to double jeopardy attack. We're talking about successive prosecutions and this Blockberger test. Let's look at the elements of the Blockberger case. The protection in double jeopardy involving multiple offenses and multiple punishments growing out of one criminal transaction, for instance. The protection against that is sometimes yields if there is clear intent by the legislature to punish two crimes if they are both committed in one criminal transaction. One example would be a drug crime where a weapon was involved and there would be a prior felony. So you have both the drug crime and felon in possession of a firearm, and those are two separate offenses. So you can be punished for the drug case, you can be punished for the felon in possession case, and those punishments can run consecutive to each other because they are separate crimes with a clear intent by the legislature to punish them as separate crimes. Then there is the separate transactions, part of the Blockberger test. Or I'm stating this improperly. These are situations where the Blockberger test does not apply. Okay, so legislative intent. And the second thing is if there are separate transactions, if you do successive criminal acts, they can be punished separately, and those punishments can run consecutive to each other. So that's separate transactions. And then the separate sovereign doctrine is an exception to the double jeopardy rule. And I'll give you an example of that. In many of the civil rights cases, people were acquitted of murder and then tried for civil rights, acquitted of murder in state court, but then tried for the same actions by the government, the federal government, for civil rights violations, criminal civil rights violations. So it's kind of like there are two prosecutions. If one's not successful, we'll let the feds try. That's perfectly legal because of the separate sovereigns doctrine. Now, whether or not, back to the Blockberger test, whether or not double jeopardy is violated has to do with if there could be multiple punishments, but there has to be some additional element to a second offense that is not proven by the proof of the first offense. So there's an example of burglary being a distinct offense from the theft. You don't have to steal something to commit burglary. Burglary is just simply breaking and entering for the purposes of committing a crime. But once inside, if you do in fact, steal something, then you have a theft that can be sentenced and tried separately. Not tried separately, but often should be tried together, but can be punished separately because they are distinct offenses, because the proof of one offense does not necessarily constitute all the elements of the second offense. All right. The next issue is severance of offenses or parties. This involves whether different charges can be tried together, and then with respect to severance of parties, whether people can be tried together in one trial setting. So offenses can be tried together if they arise out of the same act or transactions, or arise out of acts or transactions that are connected or constitutes part of a common scheme or plan. Or the third situation that the book talks about is the defense and the prosecution can consent to a trial of all offenses, just because there may be some interest on the part of the defendant to having one trial, one exposure, and the trauma of trial gets over in one setting. And certainly the state is always interested in piling as many offenses together to make a person look as guilty as they can. Sometimes people look at the number of counts in an indictment and say, gee, if they've got 8 counts against them, they must be really guilty. So it's always going to be a defendant that thinks that that's not necessarily a good idea, to have offenses joined. The state's going to almost always favor that. But then there can be situations where the state wants to join offenses, but the defense objects because joinder of the offenses would be prejudicial to the defendant's interest. And let's look at the circumstance that where that might happen. Typically, you want to sever defenses when trying them together could cause someone to look at the number of charges and just assume a person is guilty. Has to be guilty because of so many things charged. So there's some limited circumstances where you could perhaps have offenses severed, but typically you're going to have a hard time doing that because they won't be joined in the first place if there's not some temporal connection. But certainly sex crimes against two victims, perhaps, or multiple sex crimes against one victim if they're separated by time and circumstance, are the situations where you would certainly seek to sever offenses because of what the book refers to as the spillover effect. You know, if you're guilty of one thing, you're probably guilty of the other similar offense, as the jury may conclude. The issue of joining defendants for trial, the danger is that you have a circumstance where defendants have inconsistent defenses, such that if you believe defendant A, then you would have to believe that defendant B is the guilty one. So you can't try a case of two defendants together if to believe one means to disbelieve the other. Both parties have to have a reasonable opportunity to be found not guilty if they're tried together. So most commonly this involves a defendant who points the finger at the other person and says, in fact, that person did commit the crime, not me. So you might have a situation where the state would want to use a statement by a person who gave a statement, but it also implicates the defendant, the other defendant, but that person is not going to take the stand, and so they can't be cross-examined. So you have a circumstance where you can't admit person A's confession that implicates person B because person A is not going to take the stand, and person B can't cross-examine person A, and the statement that the state wants to use against person A cannot be cleaned up in such a way, or the person B's name can't be redacted in such a way that these two persons on trial, that the obvious omission of information about that person is still nonetheless present because of the either or nature of the crime, or any kind of accusation from one defendant against the other if the person doesn't testify. So the best way to do this is to simply try people separately, and that often is the case, you know, in capital cases where error is so costly, and where you know, if on appeal the court says they should have been severed, you've sunk a lot of time and resources into a joint trial when you actually have to go back and try both of them separately again. So it's best just to do that up front. So that typically is why a parties are tried separately. But you can have a situation like I have right now where people are tried together. A mother is, well, there's a dead child, and the mother's boyfriend is charged with capital murder for actually injuring the child. My client is charged with reckless murder for not protecting the child from this guy. There's a lot of things we have to work with that I believe will get cause an acquittal on behalf of my client because she didn't have prior notice of some of these circumstances that the state claims should have provided her notice. Well, what's also crucial is my client was not present when the child succumbed to whatever was either injured or succumbed to that injury. She was undisputedly somewhere away from the scene at work, some 30 miles away. So she doesn't know what happened. So she doesn't have any testimony to offer against the guy because her genuine position in this case is, I don't know what happened while I was at work. She's not pointing the finger at him, and he's not saying, well, it happened because she did it, and maybe he became symptomatic later. So where there's no antagonistic defense, those people can be tried together. I opposed them being joined, but I may in the end be just as fine that they were. That trial hasn't happened yet, so I don't know if I'll be happy or sad about the whole circumstance. The final thing is the change in this chapter is the change of venue motion. It is a very difficult thing to do to have a case, to have venue in a case changed preemptively. I say that because the courts have gotten to the point where they believe that the test of whether a trial should be moved would become evident if we try to strike a jury and find out that due to pretrial publicity or acquaintances being so close in typically a small community that they can't be tried there. You summon 100 jurors and 75 show up, and they're not enough to provide sufficient strikes for both sides who would be impartial and don't have extrajudicial knowledge, that is, knowledge of a case that came from some source other than the evidence at trial, or they somehow have an interest in the conviction or acquittal because they know someone who is a victim or defendant or a key witness, or are closely acquainted with a lawyer sometimes. But there can be situations where you would convince a judge that it's a lost cause to be able to strike a jury and do that ahead of time based on typically pretrial publicity, and you demonstrate that by polling, how much saturation is there and how firmly held are some of the opinions about the defendant or the state, as the case may be. If you watch that movie Bernie, that was actually a rare instance where the state got a change of venue because the person was so popular they couldn't find anybody in town. They couldn't find a sufficient number of jurors in town who would vote to convict. It's sometimes you can persuade a judge to move a case, but what's difficult is if they say no, getting the appellate court to reverse a denial of change of venue. Um, an exception to that would be a recent case in Montgomery County where a police officer shot a person that he was attempting. I don't know if they were attempting to arrest him so much as they were trying to defuse a situation where a mentally ill person. Maybe I'm getting the Huntsville case mixed up with the Montgomery case. No, this was a shooting. Strike that. I'm getting the Darby case in Huntsville mixed up with this Montgomery case. The Darby case being a police killing. But in this Montgomery case, it was a killing on the street where the police officer alleged that the person became aggressive, but it was pretty clearly not the case. And there was some pretrial, a lot of pretrial publicity and interest, a lot of sentiment in the community, and the judge denied a change of venue, but the Supreme Court ultimately reversed and said that there had been so much prejudicial media that the person should get a change of venue. And venue was transferred from Montgomery County to Dale County, primarily a white county. By the way, it was a white officer that killed a black person. And ultimately that officer was convicted of manslaughter versus murder, which is generally about the best you can do. Obviously, we've seen cases where it seems as if the police are not held accountable for, killings of defendants. But change of venues are fairly rare, and there was another case, a very gruesome case in Mobile County where a person killed either maybe 3 or 4 children. The man's name was Long, Loung. He had to be Vietnamese, but he took 3, if not 4 children and just tossed them off the Dauphin Island Parkway into the ocean, and was, mentally ill, not sufficiently so that he could prevail on a claim of mental disease or defect. But what happened was the court denied, there's such a celebrated case that made national news, these compelling circumstances where there were infants who were deceased. All the churches in Mobile had these vigils for the children, and their bodies were picked out of the water piecemeal along the coastline. One had drifted as far as Mississippi, and so the court denied, but the Court of Criminal Appeals looked at it and said, this is a clear case of where the degree of media and prejudicial exposure of facts to the public would keep this man from getting a fair trial in Mobile County. And people in my position who defend cases say, great, there's those situations where the court will say you can presume prejudice to the defendant based on pretrial publicity. The Supreme Court, however, shot that down, Supreme Court of Alabama, and said you can't presume prejudice even in a case as drastic as this. But it seems like to me they did exactly that in the Cody Allen case. That's the name of the defendant in the Montgomery case, and I have to think it was because the distinction was because it was a police officer. But anyway, that is the last subject in this chapter. Now let's talk about the due date for the assignment, the book report assignment. So since we're not meeting anymore this semester and can't do these reports in person, as much as I enjoy that, that's just really a highlight of the semester for me is to see students find something that interests them and get excited about it. And I always learn something, so I'm really hate we're not going to be able to do that. Also, we're not. I'm not going to require you to do a presentation and record it. So it's just going to be a book report. It's going to be a written assignment, and it will be due on the same day as your final exam, um, which is the 9th of May. And I'm going um, to give you until the end of that day. So midnight, 9th of May, you'll have the time to finish your final exam and um, also that report, and email it to me. Email it to bamalawyer@gmail.com, please. Um, and that will help me immensely rather than grading that book report online. All right. The other thing, we've got another set of, we got 2 more chapters to cover, I believe, if maybe one, but I'll deal with that next week. If there is an interest in extra credit, and there may be a need for that to be able to pull some grades up, I will think about a project and we'll have that posted. It'll be optional. If you believe that you need some uh, way to boost your failing grade into a passing grade or a C or a B up to an A, just depending on what your goals are. I would encourage you to pay attention to that. It'll be another writing assignment, an analysis assignment. That's about the only way we can do it now that we are um, stuck in our own homes and not able to congregate. All right. I think that's everything. I hope you have a good weekend.